Welcome back, everyone, to the third in our discussions about art law in our first part. So we're moving on from the artist to the work of art in the sort of widest sense. And I'd like to start with Kyle. And we've discussed this a few times now that we understand the artwork to be different in kind and in nature from other items of property. So, to what extent are there legal limits to the owner's ability freely to sell their artworks?
Well, absolutely. I mean, one of the issues that we mentioned when we were talking about the sort of unique nature of artistic objects is the fact that they are considered to be of sometimes national or indeed international cultural importance. And as a result of that, seeing them within their original context actually gives them a value. And therefore, despite the fact that the law tries, certainly in common law jurisdictions, and particularly in the United States, to allow complete freedom of owners to sell their objects in a free market however they wish, there have been moves to kind of restrict that in order to protect the very special kinds of property that come under the title artistic object. So here in the UK, we have a licensing system whereby we license the sales of cultural objects. This is a significant, there's no getting around this. This is a significant encroachment of private property rights. And therefore, it has been limited to a certain extent. It only applies, for instance, to objects which really are of huge cultural importance within the UK. This all is dealt with under the Export Control Act of 2002. And under that act, the UK government can require the vendor of an art object to apply for an export license for that art object. In order to give rise to the requirement of that license, the object must meet certain criteria with regard to both its age and its value. And those things vary according to the nature of the object. So for paintings, for instance, a painting must be at least 50 years old and worth more than £180,000. Once you've ticked those two criteria, you must go forward then to the reviewing committee on the export of works of art, and it will be them who decides whether or not you're actually allowed to export that particular work of art, either because it is sold to someone in another jurisdiction or you wish to offer it for sale in another jurisdiction. When it comes before the committee, they then will apply a series of criteria to test whether it actually is of national cultural importance. And those criteria are called the Waverley criteria. And that will decide whether to grant an export license or whether the granting of that license should be deferred so that the object can be considered for retention in the United Kingdom as a national treasure. So there are three criteria that really will decide whether an object is worthy of being retained and whether it is justifiable to overcome private property rights. They are that the object is a piece of what's called national history. That is to say, it is so closely connected with UK history and national life that its departure would actually constitute a national loss. It has to have great aesthetic importance, secondly. Is the object, is what you'll be asking yourself, of outstanding aesthetic importance? And the third criteria then is the object of scholarly significance? Is the object of great interest to academic research and study? If any one of those criteria are met before the reviewing committee, an export deferral will be imposed. So that will basically forbid the removal of the work of art from the United Kingdom, usually for a period of about 2 to 6 months. And during that time, a campaign will then start within the UK to try and find a national cultural institution which is able to match the sale price or the value of that item to buy it in itself. If no buyer comes forward, the license is normally granted and the work of art is allowed to leave the country. This is actually a significant weakness in the system. Although we tend to always hear about the great works of art that we've managed to save for the nation, many others leave because a buyer simply cannot be found who has sufficient money to purchase them. There is no government scheme in this country whereby the government have the right to step in and purchase a work of art for the nation. Instead of that, one of the cultural institutions must themselves raise the money. And that can, in certain circumstances, lead to the loss of the item. And more often than not, that is actually what happens, even though we tend to only hear about the successful cases. But
I mean,
talking
I
about
remember this vividly, how difficult it was. I was involved in obtaining an export stop and then applying the Waverley criteria in the purchase, eventual purchase by the Courtauld of this wonderful pastel, which we obtained in the preparation to an exhibition on the Royal Academy at Somerset House. So we had all sorts of really solid reasons to want this, and we got it in the end. But the money was pieced together from various kind of funds through various applications. It was a very onerous kind of process, and I think where much greater sums are involved, that might be even much more complicated as well. But I was wondering if we had something similar in the States, Steve, a
We
similar
we
provision.
we don't. The short answer, there are so we don't have that kind of level of it's nothing even remotely similar to the Waverley criteria that Kyle was describing. But there are restrictions that I think that apply in different circumstances, and I want to talk a little bit about that. For example, for Native American artifacts, in many ways, in many circumstances, are protected under federal law in the U.S. Also, archaeological preservation is strong, and there's certainly protections on that. There are also, the U.S. applies it more in terms of a tax incentive kind of thing for preservation, for cultural preservation. And so, for example, in California, I think I alluded to this in another one of the lectures that we recorded, that there's something called the Mills Act in California that relates to a sort of a property tax abatement for significant architecture, and historic value that you're able to have certified. And there are a number of different sort of tax incentives to provide for that, and that's kind of our, in the U.S., our method of dealing with that, and it's been built, sort of baked into the U.S. tax code and to various state tax codes. But it's interesting, I think, and it touches a little bit on, and maybe we'll get into this about the issues of Nazi looted art, and I think maybe I'll save that for, we'll get to that.
And
yes,
it's
well,
a
just in
great
before we
segue
do that.
to the idea of tax incentives to protect cultural heritage, which I believe, Kyle, we are quite leading in the UK.
We actually are. That's absolutely true. We have those tax breaks that Steve was talking about in the US. We have those in addition to the licensing system that exists. And actually, with the tax system that exists in England, I think you can certainly argue that the successive governments have been very clever. HMRC's guidance to those tax reliefs available to people who wish to use cultural objects to write off part of their tax liability through giving public access to them. That document continually stresses the importance of keeping these objects in private ownership while securing public access at the same time. So by doing that, the government has very cleverly divested themselves of the responsibility of caring for these objects on a day-to-day basis, but still making sure that the UK public can have a governmentally secured right of access to them. It also means that collections of objects, and quite often you tend to find that individual objects within that collection are not terribly valuable and are not of national importance, but those collections as a whole, which are worth more than the sum of their parts, are kept intact. And the single important work that's part of this much larger collection is actually kept in its original context. This is such a clever way of doing all of those things. I mean, to see the impact of this tax legislation, I think you only have to go over to France and visit, the chateau that you see over there and compare these vast empty rooms stripped of their contents to the sort of unimaginably rich cultural tapestry that you can weave from a visit to any English country house. The most significant of those reliefs, just to sort of say what they are contained in the inheritance and capital gains tax regimes, which allow for eligible objects to be exempt from those taxes if the public is given access to them. So if you've inherited a Gainsborough, if you promise to allow the public to see it in so many days of the year, you will be allowed to inherit that without paying capital gains or indeed inheritance tax on it. It's a very significant saving. In order to qualify for that, those objects must be of preeminent national, scientific, historic, or artistic interest. But it includes virtually any kind of object you can possibly imagine, or indeed a collection of objects which would otherwise be dispersed. In addition to writing off inheritance tax and capital gains tax, owners who are still alive can still settle inheritance tax or existing tax liabilities by transferring culturally significant objects to the state. So you would basically hand over an object to the V&A in order to write off your tax obligations. As I said, this regime that we have in the UK is considered to be one of the most effective and practical means of dealing this that exists anywhere in the world. And we really are the kind of envy of the rest of Europe. Now, this obviously still comes with something of a health warning. If you own a work of art worth £30 million, finding someone who has a tax liability of £30 million is often not going to be terribly easy. And in fact, I came across this in my own experience with the I did some work legally with the Russborough Foundation in Ireland, with the Sir Alfred Beit Foundation. Of course, famously a few years ago, they felt forced to sell 9 of their most important works in order to keep the roof on Russborough House itself. Now, again, the Irish government stepped in at that stage and actually offered tax breaks to anyone who would purchase these objects for the Irish state. And unfortunately, for 4 of them, they simply couldn't find anyone whose tax liability was enough to write it off against it. And so those 4 works were then exported and sold. So it's not by any means a foolproof system. However, I think we can be very proud in the UK that we have probably one of the most practical solutions to this issue, which keeps collections intact, but also means that the government are not expending any money actually looking after these things going into the future.
In the US, we are but a young country. So we don't have that, and in some ways I think that is irrelevant because we don't have that sort of cultural heritage, that goes back generations and generations and generations. And so I think that is a difference. We deal with it, as I said, more in terms of tax incentives and also charitable donation benefits and other kind of restrictions, or I would say not restrictions, other kind of benefits that you get when you're applying in that circumstance.
Yeah, and I imagine from an American perspective as well, the idea that you could be forced to show off your own private property to the public is probably something slightly distasteful as well. That the government can tell you that you have to open your house so many days every year in order to get that tax break is probably not terribly popular as an idea in the US.
In the land of quote freedom and yes, they're. I'm joking.
I mean, again, it has to be said, you do actually see, if you go along to, New York County, you can really see the price that has been paid for that, unfortunately, with those vast, empty Gilded Age mansions, which, have been abandoned. That simply wouldn't have happened in the UK.
This is slightly off topic, but I think, California has done a really great job of, for example, coastal. So there's a California Coastal Commission and of coastal access. And some of that where they do not allow private property to sort of to only be on the coast of any kind, even including in lakes. So and there's always a sort of a right, like the mean high tide line is usually where it is. So that's slightly off topic, but I wanted to just raise that as another kind of protection, right?
I'd like to move on to a more a weighty, a kind of a more painful in many ways issue of cultural heritage and its protection. When we talk about restitution, especially of Nazi looted art, and Steve, you've already alluded to this, and the repatriation of works. And this is a very contentious issue with different positions being taken, which also, I think, uneasily has overlappings of legal, moral, ethical aspects, which in some cases, Kyle, I think you believe that may pull against each other, right? And
yeah, absolutely. And just to say that from a UK perspective, we're in a bit of an odd position with this. There is no doubt that we led the way with repatriation. Prior, basically, to the Napoleonic Wars, It was considered that if you won a war under the international law principle of justum bellum, if you had defeated your enemy, you had the right to go and pillage and take whatever you liked. And that was seen as being really part of international law. It was really the British, when they attended the Congress of Vienna, and my own compatriot, I'm very proud of, Lord Castlereagh, who basically came to the Congress of Vienna and basically fought against that idea of justum bellum. The Napoleonic Wars obviously saw the largest movement of cultural property in the history of the world at that point. Places like the Vatican museums were just simply emptied and brought to Paris. So we really led the way in putting together this international concept of restitution after war, whereby things that were taken ought to be brought back, particularly those things which are of national or international significance should be put back into their original context. But having kind of invented it, we haven't really done very much with it. And actually, you've raised the question of the Holocaust, and that's actually one of the more interesting aspects of what we've done. Obviously, during the Second World War, there was increasing pressure on the Allies to return objects seized by the Nazi government from across Europe. And in 1943, there was an inter-Allied declaration, for instance, that if the Allies won the war, they would ensure that everything that had been taken would be returned very efficiently. The end of the war comes. Nothing happens. There was no political will really to do anything about this. And you don't really see this, even though there's a kind of undercurrent in Europe that something terrible had happened with cultural property during the war. Obviously, in Germany, no one wanted to talk about it, and the rest of Europe really just wanted to move on. A lot of these works had obviously made their way onto the art market. They'd been gone through several people's hands. Some of them had ended up in national institutions. No one really wanted to touch this hot potato, needless to say. It really reared its head most significantly again in 1998. So really, 50 years after the end of the war, when you had a conference in Washington looking specifically at the issue of Nazi confiscated art, and that conference set out a number of principles whereby those artworks could be repatriated and given back to its original owners really quite efficiently. That was applied with different kind of results in different places. Here in the UK, we established a spoliation advisory panel in 2000, but then we didn't enact any legislation to actually give it any powers. So virtually nothing happened with that panel until 2009, when eventually we enact the Holocaust Return of Cultural Objects Act. And that finally overcame the main issue that we had with museums in the UK, which basically was that they couldn't return objects. Once an item went into a national collection in Britain, if it was one of the big museums like Tate, the V&A, the British Museum, they needed an act of parliament in order to de-accession something. So this is really the first time you see significant inroads being made into that. And this act basically gave these museums the powers they needed to return everything that they needed to return that had been seized by the Nazis during the war. Now, again, this is one of these things, we tend to hear a lot about cases, for instance, the Adela Bock-Bauer case, where those paintings were returned to the family. We don't hear about all the ones that don't succeed, nor do we hear about how many actually end up going to hearing. And, between 2000, when it was established, and this year, the Spoliation Committee has only heard 24 cases, and the vast majority of those have been unsuccessful. So really, we haven't lived up to the potential we had for the repatriation of these artworks. And this really is going back to the difficult questions that are being asked here, and that overlap that you were talking about, Anne, between morality on the one hand and what outcome we actually want in the end. And that is a very difficult, sometimes what feels like a moral, obvious answer to a question in the pit of your stomach can lead to results that you don't really want. And in addition to that, quite often, something which may seem to have a very simple explanation as to how it ended up in this country, which means that it should be repatriated, is much more complicated. So there has been significant.
There are a couple of things that I want to say, and we only have a short amount of time left, and I really have so much to say about this issue, even though Kyle has touched on so many of the issues that I was going to talk about. But one of the things that I want to say is that Nazi looted art is and the concept of that is such a living issue. 80 years after the fact, it is a very living concept of to try to make sense of these things. And Kyle was talking about the way that the UK was talking about the way the UK is dealing with that. I wanted to touch on, for example, actually, I was just in Zurich not so long ago, and there was an exhibit in the wonderful Kunsthaus Zurich the museum of the Emil Berl collection. Emil Berl was a Swiss arms dealer, and amassed a collection that in at least in large part was either funded or directly involved with the looting of art. And one of the things that the museum was trying to sort of make determinations about, they were very, very good about having sort of questionnaires, digital questionnaires that people that were viewing it could look at, is what do we do with this? We've amassed this. Emil Berl then gave all of this art that he had collected to the museum, and what happens to this? And many of those pieces are really under advisory and under dispute and under litigation, and there were some where it said provenance in question, provenance in dispute, and I think that they did a really, really excellent job of sort of bringing this to the forefront in a very stark way. One other thing that I was going to say is that there was a case arising out of the Thyssen-Bornemisza Museum in Spain, I think in Madrid. There was a piece that was in dispute about whether actually there was no dispute that it had been looted. It had been indeed looted by the Nazis, and this sort of moves it back to the sort of issue of art law, that there was a question ultimately in the U.S. Supreme Court about which law would apply. Would it be California law, in which the the family in California would have actually get that art piece back from the museum, or Spanish law, in which the museum would and ultimately Spanish law was deemed to apply. Very complicated case. You should read about it. It's too long to sort of describe here. But one of the points that I want to make is that this is about how much of this is in the forefront of art law, is that in California, there's now an assembly bill and being signed into law that is about making California jurisdiction apply to disputes arising out of where it touches California. And that is a good example of where even again 80 years after the fact, we're all wrestling with what does this mean and what happens. And even in my art practice, I've dealt with cases that have dealt with where, for example, the buyer and seller don't know anything about that there was a potentially looted piece, but the issue remains that possibly, allegedly, there was a looted piece. And so what do you do with that? Because then you try to apply sort of the normal provisions of law, of regulatory and statutory and case law to that very thorny issue. I think that's I'll leave that matter there, but so much to talk about.
There's so much to talk about, and I think there is a whole.
Just to finish off, just
requires a specialization in itself, doesn't it? I mean, restitution law should be a kind of specialization in itself. But I think maybe we can end this conversation just with a thought that, as in society more widely, as we make developments in our legal framework, this requires conversations like this. It requires conversations in public, in universities, among people that are not necessarily narrowly focused on the law, to drive some kind of collective sense of what is the right thing to do here. Maybe that is necessary.
No, absolutely. This is what I was going to finish with. There is a reckoning, obviously, coming and a huge amount of political pressure in Britain to deal with the legacies of empire through these mechanisms. Those questions are much more complex, and that's where this overlap between morality and the law is going to become very important, and where we're going to need people who are able to answer these questions in a kind of systematic way, which will give us a kind of coherent way to deal with these legacies going forward.
Great way to stop. This has been such an interesting conversation. Thank you both so much, and we will meet again to continue this chat. Thank you. Bye bye.
Thank you, Anne.